The first thing is unintended consequences. Do you know what the theory of unintended consequences is? I'll give you a example of petrol. 4 months back, everybody was saying that petrol is too expensive, we can't afford it, fuel is expensive, prices are going up. COVID changed all that. Nobody travels anymore. So they had to give away petrol free of charge because it just keeps on coming out of the ground and you got to get rid of it. So they were even wanting to give it away free of charge or maybe delayed payment. This was an unintended in the oil industry. The same way COVID is an unintended consequence into the legal industry. Now, as I said, there have been so many ones, so many seminars that you have been going through. Now, one thing I want you to understand is this. No judge is going to ask you how many webinars you watched, you made notes of, how many webinars you were prepared for before you went in to see them, hear them. I don't think a lot of people would be bothered with reading or studying before you go into a webinar. चलो ये webinar आ गया देख लेंगे आधा घंटा निकाल लेंगे. But that is not what I'm talking about. I would like all of you to think anew. One thing I would like you to remember is that judges are human and we all think of precedents. All your what called seniors will be bringing a lot of precedents to the table. COVID is going to be different. And it is your duty, no matter what the precedent might be on the table, it is your duty to rip that precedent apart. And that is where you have got to start thinking out of the box. We had some time back, we had a nice conversation with a judge from the Admiralty, the judges who decide cases in the Navy. And he has said that we are not interested in precedents. We would like to decide on each case as if it's a new one. I think it's a good idea. You might refer to precedents. Precedents might be helping you decide what you have to say or what you do not have to say. But if you bring to the table fresh ideas and sway the judge in your direction, that would be an extremely helpful thing. Now, how do you do that? Since we are all talking of COVID these days, you would naturally have a client who would either be a plaintiff or who would be a defendant. The plaintiff usually in these cases would want money, the defendant would avoid. Now suppose you are for the defendant. That would be a more difficult position than that of a plaintiff. If any of you have heard my wife's webinar on leases and how people will try to avoid paying rents and how the landlords will be insisting on it. And there are some decisions that have gone in favor of the landlords, some that have gone in favor of the tenants or the rentees, whatever it is. You have to think in terms of both the plaintiff as well as the defendant because you're going to get both cases. Maybe as freshers, you might not get the case on your platter, on your table. The others in your organization will get them. My request is that you study each and every case that comes your way. When I say study each and every case, I mean each and every word. You may not be the ones to argue. You may not be even asked to give your input. Just read and listen and try to find faults in the other person's case, the opponent's case. That is how you will win. You will not win only on your strengths, but you will definitely win on finding faults, finding mistakes. And I can assure you, each and every pleading has a mistake. Even your pleading will have a mistake. Your business is to find the mistakes in the other side's pleadings. And that is what I mean by thinking out of the box. Just 1 minute. I'll give you an example of what happened some time back. We were co-defendants in a case in which we had actually no business being. But law being law, we were involved. And the co-defendant's advocate made a ghastly mistake. We didn't have to jump in, but we did. And within a sentence or two, we were able to bring it back on track. The other side, after the hearing, came up to us and said that, you know why people win cases? It's because you think out of the box. And that was exactly what we did. To save the day, we had to think otherwise. And COVID is going to give all you freshers a chance to think differently. I'll also refer you to some other points which will be necessary. Maybe I don't know whether you will be appearing in court in the next 10 days, 15 days, or even 6 months. But it's also a matter of presentation. When you go to court, please enter with a winning attitude. You are not there to talk, speak, give a speech, argue. You are there to win. And the only thing that ever matters, I mean, your client is not coming to you for anything else but to win. So you are there to win. There is nothing else that matters. No matter what you do, at the end of the day, your client and how do you. The first thing is win over the court, win over the bench. And the best way to do it is to be polite. Always wish the bench as soon as you start. Where you say, good morning, my lord, or good morning, your honor, sir, whatever it is, whatever the time might be. I'm for the plaintiff, or I'm for the plaintiff number 3, or I'm for defendant number 5, whatever it is. Then you start your arguments. Why do I say this? It is always nice to be pleasant to the bench. I have never ever in my life ever heard anybody wish the court. They get up and say, I'm for the defendant, I'm for the plaintiff. When you meet a friend, don't you say hello? Don't you wish them? Is it so difficult to wish the bench? All you have to do is say good morning or good evening. It's not at all difficult. But please make that a point. Another thing is be polite. If you can get your opponents angry and angry enough to shout, good. That is how they lose cases. You have to keep your cool. Pay attention to every point that the other person is making and learn to think on your feet. Like I just said to you before, within a couple of sentences, you can change the case around. This one, of course, we brought back on track, but you can change the case around. So what you have to do is think on your feet. Be alert at all times. If you have got a couple of people around you, ask them to make points, write them on a piece of paper and pass them to you, because they are not going to be able to whisper in your ear. In fact, if they do, it will be rather shabby. But they can always pass you notes and think of it. Before you go into court, there's another thing I think you should think about. And as freshers, you might be able to get a chance. It's called being the devil's advocate. I don't know whether you people know about the devil's advocate or not. But before we go to that story, I'd like Malvika and Yashank to read out a small poem to you so that we'll know where we are going.
Two roads diverged in a yellow wood, and sorry, I could not travel both. And be just one traveler, long I stood and looked down one as far as I could, to where it bent in the undergrowth. Then took the other as just as fair, and perhaps having the better claim, because it was grassy and it wanted wear. Though, as for the passing there, had worn them really about the same. And both that morning equally lay in leaves, no step had trodden black. Oh, I kept the first for another day. Yet knowing how way leads to way, I doubted if I should ever come back. I shall be telling this with a sigh. Somewhere, ages and ages hence, two roads diverged in a wood, and I took the one less travelled by, and that has made all the difference.
Now, I read out this poem to you for the simple reason that it tells you that you have to take the road less traveled by. And that is what makes all the difference. In fact, it's one of my 3 favorite poems. The other one is If, which I read yesterday, used to hang in the chambers of Justice Rohinton Nariman. I'll diverge a bit. It's a nice poem. It says, If you can fill that unforgiving minute with 60 seconds worth of distance run, the world is yours and all that's in it. And what's more, you will be a man, my son. Um, I think it's a bit sexist because it only talks of sons. But maybe we'll change the last couple of lines to include daughters and sons. We will come to that. The other one is a poem called Don't Quit. It's about 100 years. When the funds are low and the debts are high, and you want to smile, but you have to cry. And then goes on and says that when things are really bad and you're hard and you're badly hit, that's the time when you must not quit. These three poems I would like you to read them and in fact try and memorize them. Because in life and in your profession as you go along, these will stand you in good stead. If you can fight your way through, and that is what you'll be doing all your life as lawyers. Nothing like it. Now, how do you go about fighting a case? We'll come to that. The first thing you should do is we were talking of precedents just before we went on to these poems. We're talking of precedents. Precedents are something that people rely on and they hope that the judges will also rely on those. Your business is to plant the seed of doubt. Okay, so my opposition has put forward a precedent. But my lord, is that the only thing? Is there nothing else you could consider? Allow me to put forward another precedent or allow me to counter what the opposition has said and what they want to rely on in the precedent. You have to plant the seed of doubt. Remember that your old advocates will be coming up with old theories. The same beaten path as freshers start thinking anew. I'd like to refer to a fellow called Wayne Gretzky. Maybe you've not heard of him because I think he has just retired. Maybe the world's ever best ice hockey player for Canada. Best known for the 32 stitches that he has got on his face because the rubber puck hits you like a bullet. The puck is the sort of ball that they play with. It's like a carom board piece, and it flies real hard and hits you. So somebody asked him. He says, "Wayne, what makes you such a great player?" He says, "I don't go where the puck is. I go where the puck is going to be." This is how you should think when you are in court. Don't think of what is happening now. Start thinking of where the opposition is going to be. You have to be ready with that. And that is why one of the ways in which you can do it, and as I said, if you're freshers, you can form two teams. If you're for the plaintiff, form a team for the defendants. If you're for the defendants, form a team for the plaintiffs. And each of you debate in what's called the devil's advocate. Before we broke up, I was speaking of the devil's advocate. I'll also tell you what the devil's advocate is. When the Pope wants to canonize a person, make him or her a saint, they go through a process very much like a court. And the devil's advocate has to inform the pontiff why the person should be canonized as a saint or not canonized. So that person is called the devil's advocate. So you have to be the devil's advocate. If your client is the plaintiff, the devil's advocate has to be for the defendant and the other way around. That way, you will get a lot of ideas and you might even be able to outguess the opponent. You will be able to think ahead of the opponent. Another thing is, when I said be polite, there's also the matter of language. Most of you might have seen that movie. After all the girls like Leonardo DiCaprio so much. They must have seen the movie called Catch Me If You Can. There's a half an hour clip. Frank is speaking with a lot of students. The facility, the smoothness which the man carries on for half an hour You will notice that only once he stutters, and that also when he's answering a question. There is no moment. He just carries on smoothly. And that is the way you should carry on in sport. You will very often notice the other side saying, "May I have a minute, your lord? In my humble opinion, my lord." That is when they are running out of ideas. They don't know how to carry on. And that is the point in which you stab them with your dagger. Don't let them think. If they are on the back foot, keep them on the back foot and trip them. And that you can only do if you are well prepared yourself. And that is why I ask you to have a sort of a debate in your office for the opponents, for your client. Maybe, maybe it will work, maybe it will not work, but at least it will get you thinking. Another thing is language. One of the best books that we read on language, in fact, I give my wife the book on her birthday, and she gives me a book on my birthday. That's how we exchange gifts. Brian Gardner. If you can read Brian Gardner and how he writes and how he wants you to write, it's a bit of an expensive book. Fortunately, we were able to get some off the street for a couple of hundred rupees, but otherwise it costs maybe 3 or 4 thousand. But I think it's worth it, and you have to build up your library. In fact, as soon as you get your first case or you get involved in your first case, buy the Bear Act. Just buy the Bear Act because it's not very expensive. If you can spend a little bit of money, buy a nice commentary with it, and start building up your library. My wife has built up a library of about 3,000 or more books, and it comes in very handy. Unfortunately, it's at home and we can't really refer to it right now. But each and every book that you buy is going to be helpful to you. It will stand you in good stead for the rest of your life. Even if it gets old, you will remember something or the other which you can put into your case. Now, when you are arguing a case and you find that you are at a dead end, you will definitely find yourself at a dead end sometimes. You might not have that good a case, and your opponent might be riding a high horse. What do? Think out of the box. I have a client called, well, he's not a client, he's actually the cousin of a client, but he helps us out. One fellow called Dara Jalnawala. And there is another person called Dinyar J. He's also from Jalna, so I presume he's from Jalna. He's also Dinyar Jalnawala. Now, Dinyar Jalnawala is, I presume, in the UK. He's on LinkedIn as Jurist J. Yeah, that's how he calls himself. He spoke the other day about justice and injustice. I think it was a very, very important point. We always talk of justice. Your client might have a good case. The judge is inclined towards your client because that's what justice is. It is at that time that you have to remind the judge that there is something called injustice too. And Dania referred to a case. If you got your pencils out, please write it down. Justice and injustice. The case is a very old one, 1945 ACC 221. It's an English case. Crinklewood property, CRINKLEWOOD, Crinklewood property versus Leighton Investment Trust. Leighton, LEIGHTON, Leighton Investment Trust, 1945 ACC 221. The judgment was given by Viscount Russell and Lord Goddard. The latter went on to give some very excellent judgments worth reading, and I hope you have the time and you get them. If you read, besides the lucidity of the language, after all, English is their language, it's not ours. The way they write, the way they explain, sometimes it's a little bit florid, but you can remove the unnecessary parts and write precise, crisply. So language is an important thing. If you are on LinkedIn, you might have noticed it in the last 3-4 days. One of the reasons why I came into law, well, the reason why I really came into law was a book which I had read when I was about 15 years old by Earl Stanley Gardner, The Court of Last Resort. It's extremely difficult to get. Somehow or the other, I asked my ex-boss in America to get it for me. Of course, he paid only $2 and bought me a second-hand version, which of course now is locked up in the vault because I'm very afraid of losing it. Court of Last Resort. It dealt with cases of people who had been wrongly locked up. Some of them had been executed too. That time there was no DNA testing, and they took it upon themselves to let go and make sure that people who were incarcerated wrongly were let off. In fact, about a couple of years back, you might find that on one of my articles on Money Lives. You be the judge. You can note that down too. You be the judge. Money Life. That was a case where a man was locked up for some 27 years, a black man. You know, in America, black people are locked up at the drop of a hat. After 27 years in a DNA test, he was found. Now, this is where a new avenue is open to you. And again, a COVID case, which you might want to explore. Somebody's neighbor is a COVID patient. He does not go into quarantine. He keeps himself at home, doesn't tell anybody about it. There are a lot of COVID patients who don't show any symptoms. They are called asymptomatic. That means no symptoms. But they can very well pass it on to others. And that person might be very badly affected, might even die. So, if you find that somebody has not informed the authorities, quietly staying at home, meeting people as if nothing has happened, and passing on COVID, if you can find that out, do you think it's a matter for a tort? Do you think that you can take the fellow to court? In fact, take him to court to something very close to culpable homicide. Because you know that you are passing on something deadly to people. You must have, in torts, you must have learnt of the wild beast theory. Well, the wild beast is staying right next to you. He's passing on a disease to you. He's passing on a disease to your loved ones. A loved one might die. Are you going to let that fellow off the hook? That could be that could be a very important factor in COVID cases. Think of it. It will be a new thing. You are freshers. Now we go on to another topic. I was talking about the two Jalnawalas. And once I told Dara about the cliche. He was very angry with me that day about the cliche that it's better to let one person, a guilty person, off the hook rather than, it's better to let 100 guilty people off the hook rather than convict one innocent person. It's what we were talking about, that black man locked up for 27 years. And he was angry with me. He said, "Oh, don't give me cliches." But these are important things. If you can get a man off the hook who is condemned, maybe condemned to death, you will have made your career. Just one important case like that. Take it up and really study it threadbare. And if you can do that, you will have made your name as a lawyer. Here again, you got to think out of the box. Not what the court thought, but what you think is right. It will be, it's difficult. Maybe you'll get a case like that or not. In fact, I remember at law college, we had a case like that, which went on to be called the Selfos case. The man was convicted, and it was brought on as a moot court argument. And because he was convicted, of course, everybody wanted to be on the right side. That means the public prosecutor's side. And a couple of us were pushed on to defense. And when we studied the case, we literally found out that the man was wrongly convicted. It was impossible for his wife to have died with just a small dose like that, a small dose which could kill no more than a rat. And it was impossible for the tablet, which could have killed a person, to ever have been swallowed because it was too big to swallow it. In fact, they used to make them too big to swallow so that people would not ingest them by accident. So there was no case, and yet the man was convicted. These are the sort of things that you can take up as fresh lawyers. Find something that will get a man released after he has. Now remember one more thing. The rich can afford the best of lawyers. They can afford anything. And they are the ones who are rarely convicted. It's the poor man who doesn't have money for defense, who has been appointed a lawyer by the court. I hope the lawyer does his best, but it's difficult. It's difficult for me to imagine that. I'm not talking only criminal cases, even in civil cases. If a lawyer is appointed by the court, how much is he going to pay attention to your matter? So here are cases which, as freshers, because the first 1 or 2 years you're not going to have that many cases, which you can take up. Look out for them and then try to find how best to fight those cases and, if possible, reverse the conviction. Here again, as I said at the start, you will have to start thinking out of the box. The unique way which plea wants you to do. Because with force majeure being the topic of the day, the flavor of the season, everybody is going to talk of force majeure. I think you better read up on force majeure because you're going to get a lot of material on force majeure. These cases have been decided both ways. For the defendant, for the plaintiff, it depends on facts and circumstances of the case. But they have been, you'll have to decide how best you fight the case and take up both sides. Don't you? Of course, if your client has a very bad case, in that case, it is your duty to inform the client that, look, boy, it's bad. Best is to settle. Let's not go into the court, spend a lot of money and lose. If we can get out of it in some other way, I think we should. But if, of course, the client keeps on saying, no, I want to fight, I want to do this, I want to do that, there's not much you can do. Now, these are a few more points that I had made. Language and presentation. When you start your practice, the first thing you will do is start reading a lot of pleadings, cases, old cases, new ones. I was lucky that I did not have to do it. I may have been a lawyer for the last 10, 15 years, but I used to draft quite a bit. And I never, of course, you read the plaint, you read the defense statement, what they call the written statement, but you have to write in a unique way. And what is the unique way? It's a story. Every pleading is a story, and every court case, the story is the script of the movie. You are the actor, the critic is the judge. So when you start writing, I think you should note this point down. It's a very important point when you're drafting a plea, when you are for the plaintiff. Ask the plaintiff, what do you want at the end of the day? Write it down, make your points. Ask him to come after a couple of days. Spend your time thinking over it. If the plaintiff says that, no, I just want to harass the fellow, he has been very rude to me, he did this to my wife, he did this to my son, etc., etc., I want to fight him, please ask him to go somewhere else. Tell him very bluntly that we are here to fight cases, we are not here to fight people. You might lose out on a lot of money. He'll tell you, I'll give you whatever you want. Keep away from that sort of thing. Ask him what he wants at the end of the day, note it down. And after a couple of days, ask him to call again, discuss the matter with him, and then you start drafting your plaint. The first thing you should do is to write down reliefs, what you want. That is the first thing you type on your computer. 5 points, 10 points, 20 points, whatever it is. These are the points that you want relief for. You start with your reliefs. You don't start with anything else. Having written your reliefs, you make a dummy. A dummy means at the top of the page, the court, the case number, name of the plaintiff's addresses, the title page. Make that. Then the first thing you start is wish the court. And in the first three paragraphs, you must lay out the case and the reliefs that you are asking for. But please remember, there is what is called the cause of action. The biggest of advocates and the biggest of solicitors have forgotten to have a cause of action. Few years back, my wife pointed out a plaint that I was reading. She says, "Where is the cause of action?" So when you write, there must be a cause of action and a motive. A motive on the part of the defendant, and if you're for the defendants, a motive on the part of the plaintiff as to why he's come to court. So these are two very important things, cause of action and motive. Don't ever draft anything without a motive, because without a motive, it's a dead letter. You don't go to court and say, I've come to court, etc., 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 without telling why. The motive is the reason why somebody comes to court, goes to court, why you are a defendant. So these are two things that are important. These are very important. You should start your pleadings. When you start drafting, start with the reliefs sought. And as a defendant, copy the reliefs, keep them in front of you, and one by one, try to nullify them. That is how your written statement should be. Again, in your written statement, the first three paragraphs should be good enough to tell the court exactly what you are trying to say. You might have 50 pages, 100, please. 50 pages, 100 pages is meaningless in this time and day. The very first case I lost was because my client, who happened to be an advocate, gave me a written statement of 100 pages. 8.5 years of not losing a case. We lost this case. Of course, there's another problem also. That's another thing I want to tell you about. In this particular case, we were handed a forged document. I didn't know about it because being a lawyer, I thought the client would be honest enough. We got a forged document. And I believed it. I believed it to be the correct document, and I relied on it. Of course, when we lost that case, I returned the fees to the client and told the client that the client deserved to lose because you don't give false documents. Be very careful of what your clients say. 9 times out of 10, your clients might not lie to you, but they will definitely not tell you the whole truth. Oh, we do have a number of clients who are very honest with us, extremely honest with us. And that makes our life easier. And that's what wins cases. If a client tries to hide something, do you know that hiding documentary evidence and not presenting it to court is a crime? A lot of people will say, oh, we don't want to show this, or something inconvenient to you. Suppose the other side brings it up. What are you going to do then? I remember a school friend of mine sent us a bunch of papers, and I call it the paragraph 14 case. Just read paragraph 14. Just read paragraph 14. In a bunch of papers, 50, 60, 100 pages, only paragraph 14 was somehow relevant to him. He just wanted. You can't fight cases that way. You have to be very honest. So please tell your clients from day one. In this COVID cases is going to be there. People are going to hide a lot of things. It's fresh. They won't know. They won't want you to know everything. They might tell you, well, I lost a lot of money, and not show you the document of loss. They might have even made money during that time, or the other way around. So please be very careful. No matter what documents you get, please check their authenticity. It's an extremely important matter. Now, when you are freshers, you will naturally be working with people who are more experienced than you. And you might want to know with whom you should work. You will find all sorts of bosses. Before entering law, I was in business, so naturally I used to work for different firms. I was extremely lucky. Most of my bosses were excellent. They gave us free rein, they allowed us to grow. And here I would like you to listen to one quote by Shashi Tharoor, which I read a few weeks back. It says that it is only the weak who are reluctant to empower their subordinates. It is only the weak who are reluctant to empower their subordinates. This is what Shashi Tharoor says. If your boss does not want to empower you, please understand that he is weak. Change. Go somewhere else. You want a boss who will put you in on the deep end. And now we come to another anecdote in the Dano court about 6 months back. A youngish judge, Justice Kulkarni. The plaintiff was avoiding coming to court. The plaintiff knew that we had to come all the way from Bombay, drive 200 to 50 kilometers every day. And I being 79 years old, I'd get tired. Of course, we did not get tired. We would go there every day. The plaintiff then decided not to turn up. Some excuse or the other. After the rising of the court, a little bit of banter with the judge, and I said that this sort of thing has to stop. But then, what can the juniors do? They are sent by the seniors because the senior does not want to appear, and they are asked for adjournments, and the poor juniors have to come here and face the music. So Justice Kulkarni said to me, he says, I was very lucky. I joined a law firm, and the first day I went there, the owner of the firm gave me a file. He says, here, Kulkarni, read this. Go and argue it tomorrow. He said, that is how I was thrown in at the deep end. And that is how, he said, I was lucky. I started my practice on day 2, maybe on day 1. You may not be that lucky, but if you are, please grab the chance. Don't become what we call adjournment advocates. I went to court today and I got an adjournment. That's not what you're meant for. If you have to get an adjournment, okay, somebody will ask you to go and get it, but that's not lawyering. So please avoid that also. If you can get hold of some, unfortunately, it's my age, my mentors are dying out on me. I had excellent mentors in Vijay Tulpule, who used to practice crime law. Never call them criminal lawyers. For heaven's sake, nobody is a criminal lawyer. They are crime law practitioners. They are honest lawyers. They are not criminal lawyers. And Girish Bhai Desai, who used to practice on the civil side. Both of them never used to say no. They used to say, yes, go ahead and do it. This was excellent. Another person who unfortunately died many years ago and died very young, his son is also a lawyer, was Aziz Kadiani. His language in pleadings was beautiful, absolutely excellent. And he was fighting a case for me and happened to mention, I said, Mr. Kadiani, your language is so terrific. I like it very much. He said to me, he said, Bapoo, the only weapon, I repeat, the only weapon that an advocate has is language. Your language has to be perfect. Unfortunately, because we are stuck between 3 and 4 languages, we are never perfect at any one of them. I studied 6 languages. I don't think I'm perfect at any one. You have to have your language in place. Datar, somebody quoted Datar the other day. That English, do you know Arvind Datar? He takes up a lot of excellent cases. Very nice guy also, very pleasant fellow, nice human being. And he takes up these cases which interest the public more than anything else. He's in the Supreme Court, so naturally constitutional cases too. I think he's the next Nani Palkhiwala. You should read him, you should listen to him. He said that English is the language of the court and you have to be perfect. I'm sorry to say this, but English is the language of the court and it will continue to be the language of the court. Today we are living in a global village. Nobody out of this country is going to listen to your Marathi, Gujarati, Bengali, Malayali or anything. You will have to, if you want to practice abroad, if you want to be heard abroad, if you want to be in the league, if you want to fight big cases, nothing but English will do. We were in Bhutan a couple of years back. We went to the Supreme Court, made the register there, and she gave us their constitution. Their constitution was in English. And it was drafted by a very senior counsel practicing in the High Court. I think Mr. Venugopal, if I'm not mistaken. Obviously, it was done in English. So no matter what the politicians say, I'm not saying that you should not be good at your mother tongue, you should be. But unless you have a grasp of English, I don't think you'll be able to succeed too much. You might be successful in the Mofussil courts. Maybe you might even make a lot of money in Mofussil courts. There's a good lot of money in Mofussil courts. But if you really want to be at the top, well known, without English, I think all of us are at a loss. If you run into advocates, senior advocates, like I always do, whenever I meet a senior advocate, the first question I ask him is, what is your most interesting case? And here is where another mentor of mine, Bharat Doria, comes in. I asked him, I said, Bharat, what was your most interesting case? So he said it was a case. Of course, he was in a Mofussil court, Vadwan in Gujarat. Since the pleadings were handwritten, he had to accept them. But the most interesting case was where in the premises of a court, I repeat, in the premises of a court, a policeman grabbed the jewelry from one of the litigants and ran away. He says that was my most interesting case. How do I get hold of that cop, convict him, and that too in the hallowed precincts of the court itself? Such are other cases. Adesha Katra, also very senior advocate, I'd asked him. He says, my most interesting case involved coconuts. Yes, coconuts. Mr. A had a coconut right next to his fence. The coconut must have been in love with the neighbor because it started bending towards the neighbor's property. Now, were the coconuts the neighbors or were the coconuts the fellow on whose property the tree was planted? Here actually over a period of time and over a number of cases in common law, decided that vertically from your fence right up to the sky is yours. So if the coconuts are in your property and it grows in the neighbor's property, the coconuts are yours. The only question now is, can your neighbor chop down his tree, if it's allowed, of course, and deny you the coconuts because it's growing in his property? He might have something to do with it. That's a different thing. But always ask them, what, is your most favorite case? What is your most unique case? You will learn a lot from it. First of all, let us presume that you are for the plaintiff. The plaintiff comes to you and tells you, look, this is my problem. You will speak with the plaintiff for half an hour or an hour. Maybe in the initial stages, you might not be able to charge. But as you go on, please charge the client even for the first meeting, small amount, maybe a couple of thousand rupees, but please do, because a lot of them are forum shopping. They want to talk to 10 lawyers, and you don't want to waste your time. And you don't want them to come and tell you, well, that lawyer told me this and you told me that. That's not the way it works. Charge them. Once a person invests something, time, money, energy, he gets involved. So you charge them. You speak with them, find out what their problems are, and start making notes. Take down his name, address, telephone number, and ask him a simple question. Sir or madam, whatever it is, what is it that you want at the end of the day? It's an important thing. What is it that you want at the end of the day? Because after all, when he comes to you wanting something. And as I have said before, if you find that it's a bogus case where he wants to harass somebody, please show him the door and ask him not to come again. It is not for that matter. Tell him very bluntly that we are here to fight cases, we are not here to fight people. He might offer you the room for that because only the rich people have this tendency of revenge and harassment. Please don't fall into that trap. You are there to fight cases, and this is not the way to do it. Now, if it's a genuine case, you make down the notes, you ask him what he wants at the end of the day. That is extremely important. And you note it down. So tell him that you please contact me again after a couple of days, maybe 3 days, 4 days, whatever it is. The first thing you do is you go out and buy your first bare act related to that particular case. It doesn't cost much. If you have got a bit of money, more money, please buy a nice commentary on that particular bare act. This will be the start of your library, and it will be the most solid foundation that you can ever have. Of course, you can buy some other books also, good books written by, I prefer foreign authors, foreign judges for the simple reason that their language is very lucid. They get on with it. They don't, don't go around in circles. And another advantage is that you get a wider view. If you, I'll just remind me about that of listening to cases or rereading them on the net. I might forget that point, but that's another point that we should remember. We'll come to that. Now, what happens is you have asked that person what he wants. You immediately start preparing your brief, and the brief has to be brief, no more than 10 pages. Attachments, enclosures might be separately. Your brief, decide that is going to be no more than 10 pages. First thing you do is get to your computer, your laptop, whatever it is, your word processor, and start typing what the client wants. Those are the reliefs that you will be wanting from the court. Then, above those reliefs, you start drafting your plea. This is very important. The reliefs come first. They might be last in your plaint, but they have to be the first thing that you start typing. You can keep on adding to them, subtracting, changing them as time goes on, but you know what your goal is. The reliefs are your goal. Then, of course, you find out which court is the right court of jurisdiction. If you don't know it, ask somebody, look up the books, and go to the court of right jurisdiction. Say in the court of so-and-so, so-and-so, so-and-so. Case number blank of so-and-so, you're blank. Plaintiffs, your client is this, versus so-and-so, what they call the title page. You can make some dummies also on that because they will be useful, but I don't think we have the time to go into all that right now. You'll prepare that. Then, first thing, first line you write is plaint presented by so-and-so, 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 because you might not be for all the plaintiffs. There might be co-plaintiffs. Try to avoid that, be for all the plaintiffs, because then you are not working across. Date, please your honor, or date, please your lordship. That is the first line, the standard one. Then you start off. I or we, the plaintiffs, within 3 or 4 lines, get everything done. The second paragraph, And the third paragraph, two important things. Why you are there, the course of action, and try to plant the idea into the head of the judge as to what is going to follow. In those first two or three paragraphs, the gist of your pleadings must be enclosed. And I don't mean paragraphs of 1,000 pages, mind you. Try to follow the 2080 rule. You'll find that in Garner. Uh, 2080 means sentences of around 20 words, paragraphs of about 80 words. Don't write long-winded paragraphs. Nobody, by the time you go to the end of it, you'll forget what you've written in the beginning. There is also some sort of code which says that you can't use bold font. I have read pleadings by Palkhiwala in which the font is bold. I have read pleadings by others in which they have get subheadings. And I have never read in any book that you can't do it. So if it is not banned, please go ahead and do it. You are making up a story. Every pleading or every defense statement, every written statement is a story. The story involves actors, which are your clients. You might be the director or the storyteller, and the judge is the critic. So every brief has to be a story. My wife makes a lot of fun of my pleadings. She says, you don't write briefs, you write detective novels. In a way, I consider that as a compliment because each paragraph has to lead to the next. In a detective novel, you'll want to know what happens in the last chapter. Make sure that the judge, when reading your pleadings, also wants to know what's at the end of the chapter. In that case, he will read through everything. But then again, 10 pages is about all that he has the time for. So in the first three paragraphs, you must, okay, if you want, make it 4 paragraphs, but don't make it more than that. You have to lay out your case. Then each important point will be in 1 paragraph. And that point will lead to the next one. It will be a sort of a chronology. So you have to make a chronology on the side. Maybe a chronology going 10 years, 15 years, 20 years, depending on how old the matter is and what your client tells you. It will be in the matter of a chronology. So you will tell the court each thing that happened, each step going to the next. Again, as I said, it will be like a story, a detective novel. You want the judge to read. The last 3 or 4 words or the last sentence must be important enough, must be intriguing enough to make him go to the next paragraph. That's something you learn when you write advertising copy. People don't read advertising copy much, but if you can make it interesting enough, they'll go to the next paragraph. So that is how you make your pleadings. And please avoid the the legalistic cliches. Don't use legalese. Use simple English, simple language. And if you want to, there are sites which teach you plain English. I'm in contact with them, with a couple of them, which teach you just plain English. Yes, I'm 79 years old, but still I'm learning how to write. So those sites will tell you how to write. There is one chap on LinkedIn, one Andrew Pegler in Melbourne, Australia. We banter quite a bit. He will teach you how to shorten what you have written. And mind you, you can't make one draft. You'll have to make 8, 10 drafts. And every time you change even one word in a draft, you'll have to read it all over again. So you'll be thankful that there are only 10 pages and not 100. Slightest bit of a correction, please go through the whole draft because it might lead you into a very deep pit. Be very careful. So you'll have to read the drafts over and over again and don't read them immediately. Spend an hour or two, maybe even a day or two, because that will get your mind working. You'll come up with fresh ideas and go through the draft top to bottom every time. When I've stopped at paragraph number 15, I'll start from there. No. Start from the beginning every time, because you will understand where you are going, what you have said in the past. You might even find some changes to be made. Having done that, get your client to approve it. Never give any piece of paper without the approval of the client and his signature. Dangerous. There are a lot of people who come to court and say, साहब मुझे कुछ मालूम नहीं था, जो वकील साहब ने बोला उसके ऊपर मैंने सही लगा दिया. वो तो अंग्रेजी में था. That fellow is quite conversant in English. He has fought a lot of other cases in English, but this is how they behave. Of course, no court believes them, but it leaves a bad taste in the mouth. So get your client to approve. And a chartered accountant friend of mine has got a very nice habit. He purposely puts in a couple of wrong things and makes the client read the hard copy and correct it in his own handwriting, which proves that the client has read it. Of course, we don't want to go that far, but let the client and make sure that the client comes to court. The associate will ask the client whether he has read it, whether he has understood it, and make them sign. It's to save your skin. And they can't turn around and say, I didn't know what was going on. It's a dangerous thing. So having finished your brief, then you file it. Now you might be for the defendant. For the defendant, you read the plaint 2 or 3 times. First, you just read it. Don't make any marks on that. Of course, make a photocopy and start with the photocopy. Read it once, right through. You'll know exactly what is what. Then in the margins, you start making your notes in pencil, what is right and what is wrong, what is in your favor, what is not in your favor. Having done that, now you will file your written statement. There are a lot of people who say that you should not give everything in your plaint, you should not give everything in your written statement, you should keep it aside for when the court wants. Maybe it helps the court because you don't give in a lot of papers. But personally, I believe in the axiom that everything has to be laid bare at the first instance. The court wants the truth. Don't hide papers. Don't bring them out when you are forced to do it. Whatever it is, if you don't want to put it on record, at least refer to it. If it's a big book, obviously you're not going to put a big book on record, but refer to it. If you are giving any precedence with it, please don't just give the precedent. The court does not have the time. What is important in the precedent? Please lay it out in a paragraph that, my lord, please go through the precedent so-and-so, so-and-so, giving the citation. On page number so-and-so, paragraph number so-and-so, this is what is written, and copy that down. The important point. If the judge wants to go through the whole precedent, he is welcome to do it, but otherwise you know what you are going through. If on the other hand, the other side has given a precedent, look up that precedent and say that, look, my lord, they have said this, but in the same precedent, it is also written here, page so-and-so, I am quoting it, which is actually in my favor and not in theirs. This means that you have to go through the plaint with a fine comb, very fine comb, and then pick, don't cherry pick the faults in the plaint. Your defense statement, what they call the written statement, everything is a written statement. Your written statement has to punch holes in the plaint and start doing it on day 1. For all you know, if you punch in enough holes in the plaint, the other side might give up. He's on the back foot. Now you've got to trip him and make him fall. So please study the plaint very carefully. Again, in your defense statement, you don't do it just once, you read it 10 times. And again, please don't make your defense statement very big, very large. 10 pages should do about it. Of course, if the other side has got 50 pages or 100 pages or 500 pages, please tell the court that this fellow has given you 500 pages trying to make out a big case. But I do not want the court to spend its time over it. I have gone through all the 500 pages and there is repetition on page this. This 500 pages can be condensed into 10. Make it a point. Tell the court that just because he's put a mass of paper doesn't mean that he's If you'll notice, a lot of people from Haryana, Punjab joined the Navy. Uh, I've dealt with the Indian Navy, and I know a lot of them come from there, Northwest India. They used to join at 18, retire at 38 with full pension. In the meantime, they would study law. They would even graduate and study law. They're allowed to do it, and in fact, it should be encouraged. So you do your graduation and your law. Retire at 38. You're pretty young. And the next day, you become a lawyer. And what cases do you take up? Admiralty cases. Cases with the Navy. Now remember, you spent 20 years in the Navy. You know the ins and outs perfectly. Moreover, you got a law degree. And while you've been studying law, you know exactly what you're going to do. So you pay attention to those sort of cases. Before that, a lot of lawyers used to make a lot of money in admiralty cases. These guys realized that the ex-Navy chaps are taking away their business. Now, I told you the ages, 18 and 38. 38, 20 years, you get full pension. You might not have joined the Navy at 18, you might have joined the Navy at 20 or 21. So in which case, you will be 41 with full pension. They wanted to bring in 40 years as the age at which you can enter the profession. It was the wrong thing to do. You cannot win by keeping the opposition out. You have to win by destroying the opposition, by being better than they. Recently, we had this thing about don't buy Chinese goods. And we had quite a number of, in fact, Chidambaram, Ankleshwari Iyer, we were on the same page. That you can't destroy competition by keeping it out. You have to destroy it by becoming better. So this 40-year, it was of course knocked down by the Supreme Court. Then they brought in another thing. The Bar Council also wanted to. See, what you are trying to do is protect your turf. And then they said that, well, you can study law, you can become you can get your LLB, but you can't practice. We won't allow you to practice. Now, that also, I think, is extremely incorrect. Why can't you practice when you are, why can't you join the profession when you're 50? Is there any bar? I remember we were handling cases for the LIC. And one day, the competent authority, and that's the judge, said to me, he says, you people are lucky, we have to retire at 60. You people should also be forced to retire. I asked him, I said, sir, you are nearing 60, do you have children? He says, yes. Do you have grandchildren? He says, yes. What's the age of your grandchildren? He said, 4 or 5, something like that. I said, think of it this way. One night, your grandchild falls very ill. Your doctor is maybe 10, 15 kilometers away, maybe not available on the phone. At that time, we didn't have cell phones. I mean, we had them, but very few. I said, you can't contact him. But next door to you is a fresh MBBS. What will you do? Will you go to the fresh MBBS, or will you get out in your car or on your motorbike or whatever it is and go to the doctor that you have trusted all these years? He says, well, I'll go to my doctor. So I said, in that case, why can't the public go to an advocate who has got more experience than a fresher? I know most of the people who are listening into this would be very glad if all the old fogies were kicked out of the courts and the courts would be left open to them. But remember, dear fellows, one day you too will be 60 or 70 and you might face the same music. And to tell you the truth, it's unfair. And there's nothing wrong. You can always fight and win against the old guys. That will be a feather in your cap. Why are you worried? Get into the court, go in with a winning attitude.